For 1 year, Achileo Kivumbi and Ssebufu, also known as Eddy Mutwe, have been waiting for their day in court alongside others with whom they were charged with unlawful drilling. But instead of hearing evidence against them, the proceedings have repeatedly stalled. On Friday, the case was adjourned once again.
Yesterday we had gone to court expecting to have the first witnesses give their testimonies in court. But the state came and prepared and they didn't have a file. So that's how the case was adjourned. Instead of the magistrate dismissing the charges because we had prayed for dismissal under the Magistrates Court Act, where the prosecution has failed to commence trial, the magistrates just turned around and chased away the prosecutors and adjourned our matter to the 18th of September 2025.
Kivumbi, Mutwe and their co-accused were charged with unlawful drill in August 2025. A year later, the lawyer says the continued failure by the prosecution to start the trial raises serious questions about how the case is being handled.
Whereas the courts have always agreed with the prosecution to have a speedy trial, the prosecution has deliberately failed to present any witness. And we say that if the accused people are said to have committed an offense, why can't they bring witnesses and they try them? Because this offense carries a sentence of about 7 years, and they have spent a pre-trial period of 1 year. No procedure, no witness, nothing, and no bail. That affects the principle of fair, speedy trial under Article 28 of the Constitution.
While the defense lawyers believe the handling of the case may have been politically influenced, the judiciary rejects that suggestion, saying there is no such thing as a politically sensitive case and that matters are handled on a case-by-case basis.
There are many factors which affect the progress of a trial. Much of this could be the readiness of the prosecution to bring witnesses on board. It also could be something to do with the expert evidence needed in order for a matter to conclude. It could be human and other social impediments. Witnesses could be available but so distant.
For the accused, another adjournment means more waiting and continued uncertainty over a case that has yet to be tested on its evidence. The Constitution guarantees an accused person the right to a fair and speedy trial, but the lawyer says repeated postponements, particularly where the prosecution is not ready, risk turning that right into a prolonged wait for justice.
In that case of Eddy Mutwe and the colleagues, the 21, they have forced people to take plea, to plead guilty for lesser sentences. But even those ones who say they are innocent have not been given any chance to have them on a trial, and maybe they find them guilty or not guilty. We are not about the result, but we are about the process. What process has the judiciary followed?
Prosecutor is the one who is convincing court, so you have to allow him to present his case for as long as it takes. Of course, the court regulates that practice. Like similarly, it will give the same kind of time for the defense if the defense was required to make any defense. But until all of the evidence and the prosecution has closed their case, it's when a judge or a judicial officer will sit down and in not more than 60 days, give a decision on those facts. And those are the timelines.
The lawyer says the legal team intends to use the available court processes to press for the matter to either proceed without further delay or for the court to consider appropriate relief for their clients.
The Constitution guarantees us a right to association. So if they say that by the NUP people meeting and having a discussion in their own way becomes an offense, it means they are violating the Constitution that guarantees that right. And remember, the bad thing is that if you are to do such a drill, you have to seek a consent from the minister. And you know, this government, the ministers are appointed by the president. So if you are not in agreement with what the president suggests, it means you cannot access that consent. So it becomes much of a political issue than a legal issue. But we have filed a constitutional petition. We believe the constitutional petition, the constitutional court this time will come up earlier to declare such offenses unconstitutional.
The prosecution has, however, maintained that the case remains before court. The latest adjournment does not determine whether Kivumbi, Mutwe and others are guilty or innocent. That can only be established through a trial or another lawful conclusion to the proceedings.
I started this case on the 14th day of August. And to today, the 27th day of February, I have not had one witness, which I would consider absurd.
But after a year without the trial getting underway, the defense says the question is increasingly becoming not only when the state will prosecute, but whether the continued delays are themselves denying the accused justice. For Kivumbi, Mutwe and their co-accused, another adjournment means another wait. And with the defense now challenging further delays, the focus shifts back to the prosecution and whether it will finally be ready to take the case to trial. Daniel Kibet, NTV.